Good afternoon, everyone. Welcome to another Wednesday webinar with the Property Law Alliance. Welcome, Selma and Bruno.
Hi, Marley.
How
Hello,
are you
Marley.
guys? How are you guys?
Very good.
Yeah, I'm doing well. It's been an interesting week, but all in all, quite good.
Okay, that's
It
good.
has been an interesting week. Are you also super busy this week?
I haven't
It's a weird
had
week.
time for much. Yeah. So since
Month's
yeah,
end, Bruno. Month's
month
end.
end. Yeah, I suppose.
All right.
That's what's wrong. Because I must say, it's been a bit of a brutal week for me as well. And I thought, why? And I just realized it's month's end.
No, absolutely.
May the force be with you, Bruno.
And Marley, how's your week been?
Good, but good. Thank you for asking.
Oh, shame, Marley. I know how your week's been, Bruno. She's actually had a brutal week as well.
Yeah, I'm taking it day for day, but it's fine. All right, but we received quite a few questions, and it's very exciting that I see that we've had a lot of international viewers and followers. So that is definitely a good thing. We actually received a question from Andy, and it seems that he is from the UK. So I'm just going to read the question quickly to you, and then we can discuss it. All right. He says, hi, please can someone assist me? I'm currently renting a room in an HMO and have been asked to leave after a complaint from another tenant about playing music in the daytime. I'm off work due to COVID and awaiting a request to go back. I was initially spoken to by the property manager and said I would be happy to comply with not playing music, but was unaware of the situation due to the tenant not asking me themselves. To add to this, I've just come home to a 6A form starting the eviction process. I like living at my current home and would like to stay here. What are my rights, please? So Bruno, I don't know if you want to get us started on that one.
Cool, thanks so much. Right, so we, having had a look at this question, it's UK based. So this is something that obviously us as South African attorneys aren't really equipped to handle. So what we discussed, our approach to this question would be to maybe first discuss what the equivalent would be in South Africa. And once we touch on that, we can actually start having a chat about the dangers of trying to apply international systems or jurisdictions into South African context. So I don't know where the viewer is from. So I don't know if he's in the UK and he's asking us specifically to answer about UK evictions, or if he's South African, but he's researched some of the UK principles and asked us to answer it. But if we did have to apply the same very principles in South Africa, as most of you know, our rental system is governed by the Rental Housing Act and our common law. So we've got a long, rich history of laws that govern how we deal with lease agreements. One of the things, especially when it comes to multi-tenanted residences, or communes rather, where people are renting out rooms and sharing kitchens, you generally tend to find that there are house rules that govern the relationships within this commune. So this is very important. So when a person enters into a lease agreement, you generally establish a relationship with the landlord. And the landlord has certain rights and obligations, as does this tenant. But obviously now you also need to have some form of agreement with the people that you're cohabiting with. And the house rules tends to govern this, because if the house rules are uniform across the board for all the tenants, it would mean that each one has to respect the house rules. And if they fail to do so, naturally it's going to inconvenience one of the other tenants. And the power will be in the hands of the landlord to be able to deal with that tenant appropriately. So in a case like this, for example, where loud music is being played, you'd often find that the house rules would have restrictions on how loud the music is, what time the music can be played, etc. And once this is determined and there's been a complaint against this landlord, against this tenant rather, the landlord can take action, and he can send out a notice, ask the tenant to remedy the breach of the house rules and thus the agreement, and try to get it sorted out that way. What I find sometimes with house rules are there are some dispute resolution mechanisms. So depending on who's drafting the house rules, some of them do make provision for trying to resolve things internally first. So a question like this would very much be based on, what do the house rules say? What does the lease agreement say? If it's drafted properly, there's a lot of interaction that might be involved where there's a warning that's given, and then on the third warning, he'd be deemed to be in breach of the agreement, something along those lines, because the house rules you often find aren't very serious things. So it's a matter of, to keep your things labeled in the fridge. Don't touch somebody else's food. You're generally not going to receive a letter of demand if, you take somebody's apple by mistake. So
if you eat my cheese, if you eat my cheese, it's done. It's done. I'm evicting you.
So on that example, you tend to find that Silmer's cheese would probably be a term in the lease agreement where it says do not touch the cheese. But anything else that's exactly, it's because it's so material. But things that you're not going to specify by name, you generally would tend to throw in the house rules. And by doing that, you wouldn't be required every single time something goes wrong, letter of demand. I mean, it's expensive as well. It's letter of demand. So little dispute resolution mechanisms are always advised. And and that pretty much deals with it. So in this situation, if the house rules allow for it and the lease agreement allowed for it, and this tenant played music and whatever notices he received possibly were ignored, and this dispute resolution mechanisms were followed and nothing came of them, the landlord would be well within their rights, but they would have to follow everything to the letter. And that kind of covers the situation in South Africa. Silna, anything to add?
Yeah, the only thing, if it was in South Africa, I would say just keep in mind in terms of Section 5(8) of the Rental Housing Act, if the rules aren't physically attached to the lease agreement, theoretically, the rules doesn't apply to the tenant. So that would be in the context of sectional title or whatever. If the conduct rules, for instance, aren't attached to the lease agreement physically, or at least if everything was done electronically, attached as an attachment to the email with the lease agreement, Section 5(8) of the Rental Housing Act then says that those rules does not apply to the tenant and can't be enforced against the tenant. But I think you've covered it in full, Bruno, but I must say I've seen so many, I think with the world being flat these days, well, for a while now, it's quite important for people to realize that as much as we still have different currencies in countries, we have different legal systems, and it has nothing to do with each other. It is actually worlds apart. Bruno warned me on that one. So luckily I was anyway already halfway through the barking situation. So the truth is, as much as the currencies are different and the way we do things, the legal systems are so far apart. So what you see on suits, and I think we've said that a million times, what you see on suits and the stuff that Harvey Specter does can't happen in South Africa. I know for a fact that each and every one of my clients have seen Harvey Specter rocking up to people's front door at least 9 at night. And he's like, now we're going to serve you notice. And my clients are like, why can't you do that? And I'm like, because I don't have a mole on my lip. That is why. The reason why I can't is not because I don't have a mole on my lip. The reason why we can't do that is that's not how we serve. In South Africa, we use the sheriff. We can't serve in any other way. If we talk about a specific eviction notice that's done in terms of UK law, and the eviction process start by something that's served by the landlord in person, that can't happen in South African law. So I think the point I'm trying to make is keep in mind that legal systems are extremely different. South African legal system based on the Roman Dutch system, Roman Dutch law. So there is a lot of things that we, for instance, share with the legal systems in Italy, with the legal system obviously in the Netherlands, in Holland, We share a lot with them. And it's a very similar legal system, but still not the same, because we have things unique to us, like Ubuntu, that you don't really see in other legal systems. Also, we do have a lot of English law. For instance, our law of evidence carries a lot of English law. But the God honest truth is, if you ask me anything about English law, I have no idea. We don't have a jury system, for instance. That is an English law thing. So the things that you see about law in movies and on Netflix, that's not the way we practice law. And even the legal systems between, like, your bigger Commonwealth countries, even those legal systems are worlds apart. So keep in mind that Googling an answer is usually the worst plan you can ever make. We as lawyers know that, and I will very often research law in other countries, especially with regards to evictions, see how they do things. But if you don't understand what is unique South African law, you're going to struggle to bring another legal system in. So stay clear of that, and never ever in your entire life, I do not care what you do not Google your legal answers and rely on the answer that you get from Google, even if it is the most clever attorney you've ever seen. I mean, Bruno, I'll be as bold as saying, in South Africa, there's a few very good eviction lawyers, and right now looking at least, well, I'll say 3 of them. So you're looking at a few of us, but our answers on this forum might be the worst potential answers you can ever get if you apply it directly into another legal system. And the same applies from lawyers from other countries into our system. So just be aware of that.
Absolutely. And one thing that I've noticed as a real danger, so everyone already criticizes people that look for the medical answers online, right?
Yes.
And if you look at medicine online, generally you tend to find a wealth of knowledge, because there's so many people, and it's across the world. And I mean, one ailment here is an ailment elsewhere. And it does make it a lot easier. The human body is the human body. Yeah, exactly, right? And generally you tend to find that, yeah, there's different approaches, sure. But, you know, it all comes down to, this is what's wrong, and these are the different options to fix it. The law is exactly what Silna said. An eviction in South Africa is very different to an eviction anywhere else. A lease agreement in South Africa is different to a lease agreement somewhere else. So in the UK or in the US, if you're allowed to do certain things, I don't have particular examples, because I'll be honest, I don't actually know the UK law specifically on the spoliations, for instance. But as an example, if someone's allowed to lock a property in the US, you can't do that here. So having a lease agreement that provides for it is not helpful at all. And I've had so many contracts come before me where people go, no, I don't want you to draft one, but here's a contract, just have a quick read through it, tell me whether it's okay. And you start finding references to the federal system of the US. It is a bit of a problem, because we've got specific legislation, we've got Consumer Protection Act, and now in the property sphere, I'm being very particular, but we've got Alienation of Land Act for the way the properties are sold. The other countries don't have similar legislation, so you can't compare it. The Consumer Protection Act, yes, there's comparables, but you know, it's specific reference to South Africa. National Credit Act for loans. Many countries, people can lend money as they please. In South Africa, you can't. But now the big one is the Constitution. Our Constitution is very particular. We afford certain rights that basically govern how these other pieces of legislation come about, where in other countries they might not be as human rights focused. And that's something to bear in mind. If you go to court after locking somebody out in South Africa, it is going to be viewed as bad. There's no two ways about it. Your contract can say whatever you want it to say, but you do not lock somebody out without getting criticized by some form of judge or magistrate about what you did and how you did it. So I think that is something to bear in mind. And I mean, from a difference perspective, people also always come to me and I want to sue them for everything that they have. That's first of all, that's great that you see that in the movies. That's like absolutely fantastic. But we don't have a punitive system here in South Africa. In America, they punish people. So you do something wrong, you have to pay actual damages. So the cost of a hospital bed versus something that punishes you and gets money out of your pocket to the other person. Here we don't have that. Here, all our damages are somehow relatable to the person, even if it's psychological harm or whatever, psychological, emotional harm, but it's an actual damage, not punitive. It's not to punish the person. So just things like that, just bear in mind, be very careful. When you research in South Africa, then you've got a smaller pool of experts, which basically means that you don't know how many of these experts you can actually trust. So yeah, be very careful with Google.
Completely agree. All right. Thank you so much for that answer. And then I'm going to go to the next question, which we received from Dakota. She asked that what would a selling agent need to start up her own rental agency? Silna, do you maybe want to answer this one?
Yes, so well, I think we all know I'm the one that enjoys the agent questions the most. Well, the truth is, Dakota, I think it's a fantastic idea. I know for a fact that over the next few years, our rental market is going to be a whole new game. And I think for a lot of sales agents, that's been shying away from rentals. Mostly the reason why sales agents doesn't want to do rentals is the belief is it's a lot more work, and yes, you are right, for a lot less commission. Just remember, your commission on a management mandate is reoccurring, where yes, the actual commission per invoice is less than your sales commission, but it's actually a very good revenue stream. And especially if you look at the guys during lockdown, the agents, obviously that I work closely with, the guys with the big rental books didn't really feel the really hard hit of estate agents not being allowed to function even in level 4 lockdown. Yeah. So a rental book, a strong rental book for an agent, is a very, very handy thing, and it gives you annuity kind of based income. Yes, you have to do the work, but aside from your incoming inspection and then your outgoing inspection, the dramas that you have is actually few and far between if you look at your full book. So it's really worth it. How you do it is, well, you don't need anything else. If you're a sales agent, I assume that you have your FFC, Fidelity Fund Certificate, so you're registered estate agent. You don't need anything special or specific to move to rentals. You can just do it basically tomorrow. My recommendation, however, is do not do that before you have the knowledge to do it. Rentals, and I just said it before we started, and I say this boldly, and I stick to it, and even with the agencies I work with, I really believe that this is the truth. Sales are very easy law in comparison to rentals. Here and there you have like magnificent dramas on sales, and it's like complex law, but it's few and far between where you deal with big foot stewards dramas or whatever. Like it's few and far between. Rentals is a very complex part of the law. There's about 65 pieces of legislation that finds application on rentals, where on sales, on a good day, I can maybe count it around 7 pieces of legislation. So it's a very complex, my goodness, Bruno, it's like we're having like a pet shop, your dog's barking, my cat is trying to walk up my laptop, sorry. Marilee, if you can just pull out an animal on your side.
I'm in the office, so good. It's an animal.
So I think something important to realize is, even if you're the best sales agent, to take that knowledge and apply it to rentals, you're going to run into walls a few times, and that will be frustrating. The reason why rental agents get extremely frustrated is because they haven't had the training. They haven't gone through the training. Where do you get this training? Well, if you join a big national agency that has a relationship with, for instance, I'll say this because most people know this anyway. For instance, I train on rentals for Seif and Chaz Everett and Jarvis. There's a few others as well, but those agencies specifically have a rental training academy, and I personally train the majority of those agents. So I know exactly where the agents are and what kind of training they get, and this training happens on at least a monthly basis. So they are very well trained. So if you are the principal, you know that this is the kind of training that your agent's going to get. If you do not want to join an agency and you are a national agency, you want to do your own thing, I really, really recommend getting a firm like SSLR, like Bruno's firm. Get a firm involved to do the training for you, spend the money, to spend the hours to really understand how rentals work. Honestly, Bruno, I don't know about you, but I think if somebody binge watches our episodes, where are we now? We must be on like episode 12, 13. Really? It must be around there. Yeah. But if you binge watch our episodes, you're really going to already have a lot of knowledge. But I would like to see a bit of a platform, a bit of a foundation to plug all of this into. So something like that could be really handy. Training. Then proper lease agreement, proper systems. Once again, I'll recommend the TPN Leaseback Lease. You can brand it. If you buy the leaseback, you can obviously brand it according to your branding. It is something quite convenient, quite comfortable to use. And then obviously you need to get into proper vetting, proper systems. So you do your tenant vetting through TPN or the PayProp system. I will always recommend the PayProp system for practical money handling. They hold the deposits in their trust account. They have a Fidelity Fund certificate. Absolutely fantastic system. TPN on your credit vetting. Even TPN's rent book is the practical admin side on the collection and invoicing, and it's free. I think for up to 20 properties, you only start paying from there. So look at these things, start using it. Please, please, please. Do not start a rental portion of your agency in Excel. Get the right systems, get the things done, and I do definitely recommend TPN's full system and then PayProp as well. I don't know if we should be recommending things like that, but I must say I'm very comfortable.
Well, we have now, so it's okay.
It's a pleasure.
Anything goes wrong,
TPN.
it's not our problem.
Well, at least it was me and not you, Bruno. So if the worst thing that could happen is I'm going to get a thank you from Michelle Dickens and Jan Daffel. It's a pleasure, guys. I do what I can. Okay, now I'll keep quiet.
So just to answer that question from a business perspective as well, in most businesses, what you tend to find is that the businesses are closely enough related. People can pivot very easily and can grow departments and that supplement their existing core businesses, or they can pivot into something completely new, but that they're very much aware of. The problem with sales versus leasing, believe it or not, it's almost like having two completely separate businesses. Reason being that exactly what Selma said, the laws are so different. Whereas with sales, I mean, even your selling approaches are different. So even at a business operational and sales perspective, your approaches are very different. So the fact that you're an estate agent is just this umbrella term that covers, worlds that are very, they contrast each other to a certain degree. So the training is vital, but even more than that, almost kind of a mentorship, because the reality is, what systems do you use? Imagine going into a brand new business and trying to figure out what's out there. Are there people that can help me? What systems exist? How much are they? What should I be spending? Are there people that do this for me already? How do I start the business? So like, for example, for a lot of our guys, even estate agents that are just, new estate agents trying to get into the market, like PropAcademy, the company in Durban, like their training, their assistance, just with the interactions with the Estate Agency Affairs Board, is great help, because a lot of people go, listen, I know what I need to do, but every time I send an email to the EAAB, I never get a response. What do I do? And even using like a company like this got us answers when we needed answers. So it is important to kind of also know your colleagues, know your peers, and network, because that sometimes is the easiest way of getting things done.
All right, perfect. Thank you so much for that answer. All right, I'm going to go on to the next question, which we received from Claudine. I have a query regarding an outgoing inspection. If the tenant and landlords appointed a person to inspect the property together, the landlord appointed a person who completes the full list, takes numerous photos. However, the tenant hasn't signed the inspection list. The tenant receives a copy and all the photos and doesn't dispute anything noted on the list until the landlord claims for the repair of a cracked tile listed on the inspection list. Is the inspection list valid? So does both parties need to sign the inspection list, or what are the legalities regarding this? Solna, maybe you want to take this one.
Under Inspection Rental Housing Act 1 today. Bruno, you're going to have to tell me if you agree with me on this one. But the thing is, the act clearly stipulates that a joint inspection must be held and there must be a recording of the defect. There's no legislative requirement for signature of the particular document. If the parties went as far as getting a third-party inspector, which I like, by the way, I think it's a fantastic idea. I love third-party inspectors, and simply because that usually removes a lot of disputes. The fact that they got a third-party inspector means that the inspection sheet was drafted completely objectively. So the fact that the tenant did not sign the thing, it doesn't change the provisions unless the lease agreement specifically stipulates that it must be signed. But in terms of legislation, there's no requirement. And the answer is actually going to be as simple as get the third-party inspector involved and say, was that tile cracked or wasn't the tile cracked? It can't be rocket science. It was either cracked or not. And the third-party inspector, this is the reason why you have third-party inspectors. So the fact that the tenant didn't sign the document doesn't change the validity of the document, once again, unless the lease agreement specifically requires that.
No, absolutely, I agree with you. The main benefit, obviously, of having things signed, and I tell people this all the time, it's just evidentiary. The reality is he says, she says, you'll end up in a fight and nothing ever gets resolved. The signatures that just make it easier. But you don't have to sign anything. There's plenty of things you can get away with without signatures, but it's just not a good idea.
For instance, a lease agreement. I mean, a lease agreement doesn't have to be signed to be valid.
Yeah.
But, oh my actual greatness, please, 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 please never have a verbal lease agreement. Luckily, the Rental Housing Act regulation says that once they take occupation, it's deemed to be signed. But still, you want to sign things, but it's not a requirement in any way.
No, absolutely.
Okay, perfect. Thank you so much. All right, then we got a commercial scenario. It's quite long, so I'm just going to sum it up. It comes down to multiple tenants in a commercial property, and when the utilities are divided between those tenants. What happens if, let's say, one out of the 4 tenants stop trading, they're not in the premises? Are they still liable to pay for that portion of utilities? I think lockdown is a good example, because some of the companies stop trading during this time. So what are the effects thereof? I don't know, Bruno, do you maybe want to get started on this one?
So, especially for commercial properties, this is very, very common, because a lot of the a lot of the smaller charges can't be attributed to specific tenants. So you find, for example, electricity, you get your sub-meters, even water, you get your sub-meters, but your refuse removal, there is no, the rates, property rates, those don't exist. You can't give it to a specific tenant, naturally. So we then start working on a system where you prorate or prorate everything. So, and there's different ways of doing this. That's why there's no one set answer for the best approach. So it depends on the building, depends on usage. So for example, when I entered into a lease agreement a couple of years ago for office space, I remember that at that moment there was it was a school that used to cooking school. So they used to use up a lot of electricity in that building. And when I got in, they wanted to prorata the electricity. And that was one of my points of contention, where I said, well, there's no chance that my couple of cups of coffee a day is going to remotely equal to that. And now we
and your copiers.
And my copiers, yes, and my copiers versus their 50 stoves. And the argument there was they were prorating it based on square meters, which made no sense, because at the end of the day, my consumption per square meter was a lot less than their consumption per square meter. So that is something to bear in mind. So there's different ways of doing it. So you can take the building as a whole. This is the most common way. Take the building as a whole, divide it up per square meter. Once you've divided it up per square meter, each tenant has a certain portion and a certain percentage of the building as a whole. And that's the portion that they pay towards whatever consumption charges exist. Normally, if a specific unit is empty, there wouldn't be any consumption on that unit, one would anticipate. So whatever used to be in that unit would then be subdivided again, prorated with the rest of the tenants. I know with a lot of lease agreements, they don't go into that. So a lot of them just keep it simple and say, listen, you 5%, you 5%. You pay 5%. So even if the building empties out completely, you've only got 5%. So you pay 5 of property rates. And that almost places an obligation on the landlord to ensure that if the building does empty out, he gets new tenants, because he's not going to get your contribution towards property rates for everyone else. But there's different ways of doing it. So it really depends on the wording of the lease agreement, but there's always some form of division, normally based on space. And that's pretty much it from my side.
I agree. I agree with that. I think the problem with this particular viewer's question, Marilee, is the truth is the way that the question is asked does feel like the lease agreement does allow the landlord to just divide it between the amount of tenants that not between the actual space used. And the truth is, Bruno, I think you got it as that as well. So if that is the situation, and there were 4 tenants and now we only have 2, then the remaining 2 will pay more. And unfortunately, if the agreement was concluded to that effect, you can't change it now. That is sort of the thing that causes great heartache and despair, is once a contract is concluded, it is what it is. You can't go back now and say, oh, but this is a problem. Now, you agree to it, and we have a principle in law, caveat subscriptor, which says that you need to, whoever enters into an agreement, signs an agreement, concludes an agreement, has to understand and be careful when entering into a contract, because you will be bound to that contract. And I think, unfortunately, that is the position for this particular tenant. You can't go back afterwards and say, okay, but it's unfair. Okay, I see it's unfair, and I agree with you. It is unfair, but that is the terms of your agreement. So I think, Bruno, your advice on your office space, on the office, on the ovens and stoves in the other building, this is our advice to tenants entering into agreements. Do not just get so excited about your space to just sign the agreement, because you will be bound to that contract. Do the research, do the investigating. If you have to go Sherlock Holmes on the situation, do that. So you know that the contract that you are signing and the terms that you are agreeing to are actually terms that you will be comfortable with in any potential scenario in the future.
All right, perfect.
Sorry, my dogs are barking in the background, but I'm gonna try.
Go on.
I think this again touches on the importance of just making sure that someone with some level of experience looks at these contracts, because noticing that is actually something that immediately was a red flag. And it was from experience. So as soon as I saw pro rata, and I thought, why would they do that to electricity? I'm sure people are running very expensive servers here. And then the thought dawned on me, hold on, wait, there's there's actual international cooking school up on one of the floors as well. And I suppose the reality is it's that kind of training and that experience. So if you've got it, cool. If you can read a lease agreement, kind of break it down and run through scenarios in your head. But the problem is, it seems fair to go, yeah, well, you know what, the tenants will share it amongst themselves. But what does that mean if you're the only tenant left and you now need to pay 100% of the property rates? You've agreed to it. Unless they hit it, and it's something that was so ambiguous that you had no idea what he was trying to say, then you could fight it. But if in a clear reading it says, listen, tenants will share it equally amongst each other. Sorry, you're a tenant and you have to share it. You have to pay it because there's no one else to pay it.
Yes.
Okay, perfect. Thank you so much for that answer. That is about the questions that we received during this week. I don't know if you want to discuss anything further. Any interesting things happening the past week in property law?
Life right now is so interesting, I think, for all of us. But I don't have anything specific to add to this one, except for I'm sorry we're pre-recording today. Well, I'm not sorry, but I mean for our viewers, apologies for not doing a live session today. Our diaries didn't allow for that today. But if you have more questions, obviously please comment, and we will catch it for you next week. But luckily, I think most of the times it's rare that we get a question during the session. But I just thought I should mention, yes, it's still this bright because it's still like, what time is it? 4:30. So when you watch this at 7:30, no, we're not in a different country. It's a pre-recorded session.
All right, perfect. All right, well, thank you so much for joining, Silna and Bruno, and thank you so much for all the viewers, and have a lovely week, and then we look forward to our next Wednesday webinar.
Awesome. Thanks so much, guys.
Thank you, guys.
Bye.
Bye-bye.